GP for Services 1, Ramesh Kumar. Site President, Mutagara.
Yes. Time dictated. Yes, all these interfaces are being disposed of by way of a common order, and the issue raised in all these interfaces is running the same. It's interface number 1098 of 2023, 1089 of 2023, 1099 of 2023. And 1105 of 2023 and 1106 of 2023 and 1116 of 2023 are all filed by State of Telangana and the Telangana State Level Recruitment Board. Agreed by the orders passed in writ petition number 18748 of 2023 and batch dated 9th October 2023. The petitioners as filed by the writ petitioners contending that some more questions were to be deleted from the scheme of examination as some of the questions on the ground on the ground that the questions were capable of yielding to multiple answers and there is no correct answer being provided to certain questions. Third, EP for services 1 for the appellants. I don't know, senior principal. M. Ramakant Reddy appearing for Telangana State Level Police Recruitment Board and GP for services for state government and senior Counsel G. Vidyasagar appearing for the appellants in writ appeal number 1107 of 2023 and writ appeal number 1119 of 2023 and Vladimir in the writ appeal filed by the state. It has been contended by the appellant state as well as state level police recruitment board that they have issued How many posts are notified, sir? In all, 15,644 posts were notified. And what else? Job. Preliminary test followed up by final examination. That consisted of preliminary examination followed up by physical efficiency test and final examination. And the appellants have conducted the appellant board has conducted the examination, final examination on 30/4/2023. And the final written examination consisted of objective type questions having 4 multiple options of answers, and a candidate has to mark only the nearest appropriate answer to any of the questions. The appellate board has published the preliminary key on 22/5/2023 and invited objections to the questions which had appeared in the final examination. Several candidates have filed their objections with regard to correctness of the question and also to the correctness of the preliminary key, and has published the final key on 30/5/2023. And some of the respondent have some of the respondent candidates who were unsuccessful, who have appeared for the final examination as filed writ petitions, that is writ petition number 187/46 of 23 and batch of cases before this honorable court, challenging the partly allowed the writ petitions by directing to delete question number 122, 130, and 144 and question number 57 without appreciating any of the contentions raised with the
Let's see.
of
57 of booklet C.
144 and question number 57 of booklet C, and directed the appellant board to redo the exercise by deleting the marks awarded to the candidates afresh without appreciating any of the contentions raised by the appellant board. The counsel for the appellant board has contended in paras 50 of the judgment of the learned single judge. The single judge has to the objections received from various candidates. When the learned single judge has he has come to such a conclusion. The Leonard Single judge could not have deleted 4 questions from the scheme of examination and could not have directed the opponent board to redo the exercise afresh by deleting 4 questions, which runs contrary to the finding recorded by the Leonard Single judge in the preceding paragraph. The counsel for the opponent board was further the Leonard Single judge was not justified in interfering with the questions and the Leonard Single judge could not have directed to delete 4 questions from the scheme of examination. The counsel for the opponent board had contended that, but body committee has come to a conclusion by nearly not translating the key answer that the question paper booklet will be printed in 2 languages, English/Telugu or English or Urdu. In case of any doubt or ambiguity in any question, then the English version is to be considered as the correct version. Admittedly, there was no error in the English version. The only issue raised by the respondents was that respondent candidates was that the candidates has made it very clear that the only English version of the questions have to be taken into account for finality. But the Leonard Single judge has allowed the writ petitions and directed to delete 3 questions on the ground of not properly translating the answers in Telugu. The counsel for the opponent board has further contended that in respect of question number 57 of booklet numbers of booklet C, the in a different way also, that alone cannot be a ground to delete question number 57 from the scheme of examination. The counsel for the appellate board as well as EP for state has contended that the issue was clearly covered by judgment rendered by the Honorable Supreme Court in Ran Vijay Singh versus Uttar Pradesh, State of Uttar Pradesh, reported in 2018 to a appellate board at further contended the burden of proving that the answers furnished to the furnished in the final key are demonstrably wrong by the candidates and burden lies on the candidate. Nowhere in the writ affidavit nor any contention was raised that the answer provided in the final key was demonstrably wrong, except saying that the answers were not properly translated in Telugu. That can't be a ground to set aside the questions from the scheme of it. Very slow in interfering with the correctness of the questions. More so, the answers were finalized after taking opinion from the subject opinion. Therefore, Leonard single judge was not justified in interfering with the questions the counsel for the appellant board had further contended because of the orders passed to the Leonard single judge. 15,644 vacancies could not be finalized, and the final results were already published by the appellant board on 4/10/2023. Because of pendency of the cases and the present writ appeal, the recruitment process is being delayed. Therefore, appropriate orders be passed in the writ appeal 9 of 2023, 1137 of 2023 had contended that in all there are nearly another 9 questions which were not considered by the Leonard single judge, and to strengthen their argument, they have argued that each of the questions each of the disputed questions is defective, and those questions छोटा ये सब separate noted down serious argument. International. People got nine.
1107. And there was
Clinical చూడాలా కిందకి వెళ్ళిపోతుంది ఓపెన్ చేయండి చేస్తే ये दूसरा डुप्लीकेट दीजिए उसमें लिखिए
मेन बंडल के ऊपर
1098.
yesterday 2-3 bundles are picked up from the church.
Yes,
Tell me that.
107
Madam, 1107.
and the first part.
First.
Last part with contact on. Sorry. 37. 11, maybe 11 last.
Last.
Therefore, finally, key which was prepared contrary to the certain textbook. That is intermediate standard, and to that extent, the land council for the appellant
correct
has relied upon.
as demonstrated that question number 75 94 102 question number 1
17. 1.
I 21 and one shop.
you said 75 94 99 102
117.
117 126 and 175 ఇంకొకటి and 21 and contained the run single digit ought to have also dealt in respect of these questions as admittedly the appellant respondent appellant / respondent could demonstrate before the single judge with authority that the answers furnished in the final key are contrary capable of yielding multiple answers, and that is the reason the appellant candidates could not answer those questions. properly, and that has that has that has examination so as to ensure that so as to ensure that justice is done to all the candidates for the mistake committed by the respondent board. The candidates, the meritorious candidate should not suffer. Therefore, appropriate orders be passed in the appeals referred by the candidates by deleting the questions such as question number 21, 75, 94, 99, 102, 120. Uh, 147 and 175. In the unemployed youth will be installed. Huh? Appellant candidates had also relied upon a judgment rendered by the Honorable Supreme Court in Vikesh Kumar Gupta and another versus State of Rajasthan, wherein wherein has in fact directed that the final key along with the expert opinion should be furnished to the candidates in order to, in order to have a transparency in the recruitment process. No prejudice would be caused if the opponent board will definitely will not disagree with the preliminary key prepared by the opponent board. Therefore, in order to have a transparency in the entire examination process. Let the disputed questions be referred to an independent body of experts, and that exercise can be done by the appellant board within a period of 2 weeks, and later later the selections can be finalized depending upon the expert body's opinion. The appellant candidates are not contending that the benefit should be extended only to the appellant candidates, but to the entire persons who have appeared for the examination. In order to have a transparency in the system, in the interest of justice, let the disputed questions be referred to independent body of experts, and thereafterwards let the selection be finalized depending upon the opinion of independent body of experts. This court, this court having considered.
My contention referred to because it's a different appeal. Argued as a defense.
Correct. Counsel appearing for the reported in 2021 2SCC page 309, wherein the Honorable Supreme Court held that was not it is not open for the division bench to examine the correctness of the
Court opinion must be
16 again.
14.
Okay.
Give difference and consideration to the recommendation of the expert committee. The bad expert is division.
Held that to the recommendation of expert body who have the expertise to evaluate and make recommendations. In the instant case, disputed questions were referred to expert body along with the objections, and expert body has opined and finalized the final case. The question of referring once again to the independent body would not arise. Therefore, there are no merits to appeal. అది చెప్పాం కదా మీ అప్పీల్లో సేమ్ ఆర్గ్యుమెంట్ ఉంటుంది కదా మీరు అప్పీల్లో ఆర్గ్యూ చేసిందే కదా.
30.4 and 30.5 maybe. Court should presume the correctness of key answers and proceed on the assumption, and in the event of doubt, there is
The counsel for the appellant board has further payment see page 357 and the Honorable Supreme Court held that
number
being on 30.4 and 30.5.
The court should presume the correctness of the key answers and proceed on that assumption. And even if there is a doubt, the benefit should go to the examination authority rather than to the candidate. Admittedly, if there is any benefits are not properly translated and one of the answer is improperly spelled, therefore there are no merits. All these writ appeals filed by the appellant candidates are liable to be dismissed, and the writ appeals filed by the recruitment board are liable to be allowed. Any other contentions or anybody? ఇంకేమైనా చెప్తారా?
It's something raised.
You have not filed an appeal. How can you argue?
No, but they counter it. The counter is 130, there was one are raised.
Huh?
There are the application counter. How many percentage of candidates have?
No. You have not raised, yes, furnished one details. None of the petitioners.
Counter in the, before the land single, that is not overall objections, candidates.
There is overall objections, not petitioners.
They never said the petitioners have not said, they said these are all the. Objections on instructions, we not have given 19/12/2000. The appeal we got on 19/12.
Yes, yes.
This court called for instruction, we not have submitted. All the
Yes.
candidates given instructions were not.
Okay, this court having considered. Rival submissions made by the party in the considered. The learning would make it clear. 16, 15, make it clear that the Reverend Single Judge has come to a conclusion that the key answers cannot be interfered. As the final key was finalized by the body of experts, and the Reverend Single Judge declined to. When team of experts have held that the questions were properly framed, but in order to install confidence in the unemployed youth, and when questions are being doubted by the candidates in the form of objections, this court is of the considered in order to resolve the entire issue once for all. This court deems fit to refer all the disputed questions to a body of independent experts and finalize the selections after duly taking second opinion from the independent body of experts. And this would cause no prejudice to the appellant board nor to the candidates, and it would clear the minds of unemployed youth, and it will instill great confidence in the recruiting agency itself. Therefore, this court is of the considered youth. And for the reasons stated above, this court directs the appellant board to refer the disputed questions to a body of experts, an independent body of experts of to be constituted by Usmania University. Huh? Huh? And the appellant board would ensure that the same body of
We are also anxious to complete.
okay.
Upper limit, you'll have to put it for 4 weeks.
Disputed questions.
Any questions again? They may say that our case should also be different.
This exercise